On Monday, August 12th, DHS posted for public inspection a final public charge rule that will reshape our legal immigration system and threaten the well-being of millions of families. We anticipate the rule's formal publication in the Federal Register on Wednesday, August 14th. Once published, and unless halted in court, the rule will go into effect 60 days later. This rule dramatically changes the standard by which DHS determines whether an applicant for adjustment of status or admission is likely to become a public charge and therefore inadmissible to the United States. Under current policy, DHS regards as a public charge someone primarily dependent on government assistance. Generally, a sufficient affidavit of support is enough to establish that an adjustment applicant will not become a public charge. Under the final rule, DHS will consider as a public charge anyone receiving one or more specified public benefits for more than 12 months in the aggregate within any 36-month period. A sufficient affidavit of support will not be outcome determinative. Rather, DHS will apply a totality of circumstances test featuring a range of positive and negative factors. One heavily weighted negative factor is an applicant's receipt of specified public benefits for more than 12 months in the aggregate within any 36-month period, beginning no earlier than the 36 months prior to the application for adjustment of status or admission. Critically, DHS will not regard as a negative factor the receipt of specified benefits prior to the rule's effective date, with the exception of the cash assistance and long-term institutionalization benefits that DHS already considers relevant to the public charge determination under current policy. Under the rule, DHS would also conduct a more limited public charge determination of non-immigrants seeking a change or extension of status. It's important to note that some immigrants are exempt from public charge determinations. The rule will have profoundly harmful consequences throughout the nation. To begin with, it will erect substantial barriers to legal immigration in the United States. The rule could result in spikes in denial rates of adjustment of status applications subject to public charge determinations, forcing many families to choose between separation on the one hand and leaving the United States together on the other. It also imposes a complex and nebulous legal standard that will produce inconsistent, if not outright arbitrary, adjudications. And it compels USCIS to process hundreds of thousands of new, lengthy forms each year that will heighten the agency's already crisis-level case backlog. The Trump administration's invisible wall, a wall made of policies and practices that restrict legal immigration, will grow dramatically higher. The rule will also compound the chilling effect that has already swept through immigrant communities following publication of DHS's proposed public charge rule in 2018. A July 2019 Urban Institute study found that about 14% of adults in immigrant families disclosed that they or a family member opted not to participate in a non-cash public benefit program in 2018 due to concern over jeopardizing their green card eligibility. The final rule will likely deter even greater numbers of individuals from obtaining vital medical assistance and meeting other basic needs, even when receipt of the benefits in question is not penalized under the rule. In short, this mean-spirited measure places at risk the health and safety of families throughout the nation. In its final rule, DHS noted its expectation that the State Department will align its own public charge policy with DHS's. Even prior to DHS's publication of its proposed rule in 2018, the State Department had changed its public charge policy significantly, changes that have resulted in a striking rise in visa denials on public charge grounds. Further changes to State Department policy made to align with DHS's final rule could result in even higher rates of such visa denials. Separately from the DHS rule, the Department of Justice is developing a rule that will change its policy regarding inadmissibility and deportability on public charge grounds. DHS states in its final rule that it, and I quote, will work with DOJ to ensure consistent application of the public charge ground of inadmissibility. AILA will continue to monitor and keep members apprised of the progress of the DOJ rule, as well as further changes to State Department policy. Yes, organizations will move swiftly to litigate. In addition, Representative Judy Chu has introduced legislation that would prohibit the use of federal funds for implementing the rule. The ultimate fate of this rule, however, will almost assuredly be decided in court. AILA will monitor and notify members of litigation developments. Educate yourself and your clients. AILA maintains a webpage dedicated to the public charge policies of USCIS, DOJ, and the State Department. Already, AILA has posted on that site a copy of the final DHS rule. In the coming days and weeks, AILA will post a practice alert and practice pointer that will help members better understand and respond to DHS's new public charge policy. We'll also post additional helpful materials developed by partner organizations. We encourage members to access these resources, as well as take advantage of any relevant training sessions that arise to best navigate and advise clients on the shifting public charge landscape. At a time of profound changes to the legal immigration system, AILA will continue to serve and support our members every step of the way.